Hi, good afternoon, everyone. Welcome to our community conference call that we hold every other Thursday. Today is May 28th, 2015. My name is Rajiv S. Khanna, and from the law offices of Rajiv S. Khanna, immigration.com. Very quickly, just to let you know, while I'm talking, you can tweet to me if you like. My Twitter account is immigration.com. Twitter account, immigration.com. You can also go to immigration.com, our website, and on the right hand side, you will see our Twitter feed. On the top are our connections to the rest of the social media, including our apps, Pinterest, Facebook, YouTube, etc. You can also see the Twitter feed and communicate with us on Twitter while I'm talking from our forums. On the forums also, on the right hand side, you will see the Twitter feed. Let me close these and just keep the Twitter open. Twitter is immigration.com without the dot, immigration.com. All right, that said, the way I normally do these calls is first we'll deal with all the frequently asked questions, and I will ask follow-ups on only the frequently asked questions. Then I'll start dealing with the rest of the posted questions, then do follow-ups on the posted questions. If time remains, then we will do new questions. Let me get started with the frequently asked questions first. Okay. The first frequently asked question deals with travel while the H-4 EAD is pending. So there were three sets of questions dealing with H-4 EAD. So let me first give you what USCIS has made clear in the frequently asked questions. Question: can I travel while my form I-765 is pending? So the answer is there are two possible situations. If you are already in H-4 status, USCIS says you can travel. Of course, you will need a visa to enter. And if you're a 765, your EAD is approved while you're outside USA, no problem. But they say we advise you not to travel because this can cause you delays. And the delays, the reason they give for delays is what if we issue an RFE? Well, that's not a problem. If you have a lawyer or somebody else helping you, they can take care of the RFE or the notice of intent to deny. Or if they schedule you for a for fingerprinting, etc., in an application support center, you can always be informed and you can come back. So it looks like if you are already in H-4 status, traveling while the 765 is pending is not a problem. However, if you are applying for H-4 status, the old law was and still remains, if you travel when your change of status application is pending, then you are out of luck. Your application is deemed to be abandoned, and they will also deny the 765. That said, let me see what Atit said about. Atit is the person who posted these questions. He had some good comments, kind comments about our work. Thank you, Atit. So let's look at, I'm in my third year of H-1B. I-140 is approved, filing for spouse on May 26, but she needs to travel. Okay. Will it be okay for her to travel while H-4 EAD is pending? And the answer is, like I said, if she's already on H-4 and she's got an H-4 visa to come back into USA, I don't see any problem. How long will the petition take to come to a decision? There can be no estimate. What the government has said is that, look, if you file for H-4 and EAD at the same time, we have by regulations 90 days to adjudicate the 765, but we will not begin that time to run until the H-4 is decided. That's probably the approach they will take. Okay. What happens if her H-4 EAD gets approved while she's in India? That's not a problem. Does she have to go to the US Embassy again? No, that's a visa. Visa has nothing to do with her H-4 EAD. Okay. What happens if her H-4 EAD petition gets denied? Will she be able to retain her H-4 status? Absolutely. Look at it like this. The H-4 is the first floor of the building and EAD is the second floor of the building. If the first floor of the building is destroyed, the second floor automatically falls. So if the H-4 for some reason is violated or denied, EAD has no way of existing. If, on the other hand, we knock off the second floor, the first floor can stand by itself. So the status can stand by itself, or the visas can stand by itself, and the EAD denial does not affect it. Okay. Would I suggest, would it be okay? I think it's okay to travel, Atit. Um, I mean, if you have to travel, of course, the three reasons the government gave were kind of lame, and I don't see why that should be a big problem. So, as long as you're comfortable with it, of course, they could come up with some new reasons and new problems that we haven't thought of. It's up to you. If you can avoid travel, avoid it by all means. If you must travel, go ahead and travel. I think it'll be okay. Before I open the floor for follow-ups on these issues, let me get to two other H4 EAD questions. I know there were two more. That's not it. Here is another one. You may file, this is from Rekha. Rekha says, the USCI states you may file I-765 with 539, which is the change of status. USCIS will not process 765 until they have adjudicated the 539. Part of the reason that they do it that way is because then they are constrained to a 90-day deadline. See, if they start adjudicating both together, the moment they open the 765, they got 90 days. If they start doing both together, they may not be able to meet the deadline. Okay, they're already having trouble meeting the deadline of 90 days for EAD cases. In fact, there's a class action lawsuit or putative class action lawsuit filed against the government for delaying EADs beyond 90 days. In our case, my spouse's employer will file our extension, but they're not willing to file the 765 as it is a new process. I was wondering if I need to wait to receive approval. Okay, here's another thing. If you look at the frequently asked questions, they say, okay, let's say on May 26th, your H4 is pending. Your change of status is pending. Should you file your EAD? And the answer is you can, but government has said this can cause delays because it might be difficult for them to, oh, something is happening. Some reason the calls got dropped. I'll keep going with the recording. I'm not sure what happened. What my monitor shows is that all the calls except it looks like mine, even mine is dropped. Okay, let me just log into the conference again, folks. Hang on. Okay, so we are back. There was a little glitch in the conference. All right, so going back to the part about when the government is likely to start acting on pending cases. What I said was government is discouraging you to file or from filing 765 while the I-539 is pending. They say either file both together or wait till the 539 is approved, then file your 765. Now, I don't know what I can advise Rekhaji, but it appears to me that's probably sound advice. If your company's lawyers, your husband's company's lawyers are not willing to include the 765 with the filing, maybe you can request to get the package and file the package yourself. I don't know how you would do it, but that's something you've got to work out with your lawyers. If they're not going to do it, then maybe the better option is to wait till the 539 is approved, then file the 765. And then government will have 90 days to act on your application. Okay. And the last fact on the H-4 EAD was from Archis, who said, my husband got his I-140 approved from his previous employer. Then he changed his employer, filed his LC. His previous employer has withdrawn the I-140. He's in his 11th year of H-1. Well, here is the interesting thing. You said he's in his 11th year of H1. Did he get his H1 approval for 1 year or 3 years? If he got it for 1 year, you might still be able to get H4 EAD filed. But if he got a 3-year approval or more than 1 year approval based upon the I-140 rather than the PERM application, you may not qualify. And In fact, the government has said if you are basing your H-4 EAD filing upon the I-140 and the I-140 is withdrawn, you're no longer eligible to file the application. And somebody has asked the question, well, what if my EAD is approved and then the I-140 is withdrawn? And the government has said, even then, we reserve the right to revoke your H-4. Okay. So no, you cannot file unless there is something, unless you qualify under one of the two grounds, I-140 or 1-year extension based upon labor cert. Okay. So that said, if you folks have any questions, once again, I repeat, you can tweet to me while I'm talking. My Twitter handle is immigration.com, and you can also reach our tweets from immigration.com or the forums in the right-hand side margin. Okay, anybody has any questions on these three sets of issues that I discussed? Press *5. Any follow-ups on H-4 EAD that I discussed? *5. No new questions, just follow-ups. Press *5 on your phone, please. One person. Okay, so two people. Okay, all right. I'm going to unmute you in the order you called in. I think this might be one of our existing clients. The name is familiar. Go ahead, Michigan. Go ahead, please.
Good afternoon. My question is about the filing of 765 and 539 together.
Yes, ma'am.
Now, what happens when you receive an acknowledgement for a 765? Is that sufficient?
I think that certainly should make it possible for us to file the EAD and for the government to connect the EAD with the H-4 filing. My suspicion is, this is what I suspect. I have no reason to say that this is what government is thinking. But I think what they're saying is, even if you have a receipt, it might be difficult for us because logistically they have a lot of applications to deal with in a relatively short period of time. So it could be problematic. It's hard for me to decide, Rekhaji. I think you can take your pick either way. You can file it now or wait till the H-4 is approved. If you wait till the H-4 is approved, maybe you'll lose a week, 2 weeks. Difficult for me to say. But if you file and then it's not connected, you would have no way of knowing where the application is, and it's very difficult to track it down. Difficult decision. I don't have a definitive answer for you. Sorry. All right?
Thank you so much.
You're welcome. Good luck. And the next question is from Pennsylvania. Go ahead, Pennsylvania.
Rajiv, good afternoon. This is Naga. I'm a US citizen. And can I file green card for my brother's daughter and son-in-law?
Sir, I had specifically said no new questions. Only questions related to H-4. And I'll get to you at the end of the calls, okay? Sorry. All right, so we got to maintain an order here, guys. All right, so I'm going to move on to the others since there are no follow-up questions. Let's go to the other frequently asked questions. So we dealt with this. Let's get to one question from Ramesh is H1 versus TN, which one is better? Well, H1 is subject to a quota. You've got a timeline. You've got to file in April. You can get started in October if you get through the lottery. A TN has no quota. TN can be filed at any time. H1 is a lot more expensive to file. TN is a lot cheaper. H1 is dilatory, takes time. TN can be very quick. Show up at the border. You got your approval. TN is indefinitely renewable. There is no limit on TN. H1 quota has a H1 has a maximum limit of 6 years. But the problem is you cannot file a green card while you're on TN. So somewhere along the line, either you have to convert to H1 during the green card filing, or you have to start with the H1. But remember, you can go from H1 to TN or TN to H1 without any issues. H1 allows you to have a green card filing done, but TN does not. So let's look at the questions Ramesh says. Ramesh has, I'm a Canadian citizen living in Canada, computer engineer, business for 8+ years. A small business in the US wants me to work for them. Should I go for H1 or a TN? See, Ramesh, right now the H1 quota is gone, so you might as well start on TN. The company that wants to hire me is a very small company. Is that a problem? As long as they have, see, for H1, that's not a problem. Usually for TN, it's not a problem. For green card, as long as they are paying you enough and they have enough money in their tax returns, it should not be a problem. We have done green cards for companies as small as one employee companies. Okay. And H1 works better than TN for this purpose. Does anybody have any questions on TN H1 relationship? Press *5. *5, TN H1. No new questions. TN H1 relationship. Okay. So we've got one question. And this is from California. California, go ahead, please.
Yeah, hi. My name is Pinky. So regarding the TN H1 visa that you spoke about, so right now since H1 is the quota is over, that means he should come here on T1 for now, TN for now, and then but then we can always file labor for him because labor is not associated with a particular employee. So can we at least start the labor process for him?
Actually, labor is associated with a particular employee, but your reasoning may be faulty, but your thinking is sound. What happens is TN does not allow you to file an immigrant visa. A perm application, a labor application, is not immigrant visa. Immigrant visa is I-140. So once the perm is approved, okay, once the perm is approved, you've got to file I-140 within 180 days. So up until
Okay.
the time I-140 is filed, he can travel in and out, no problem. Once the I-140 is filed, he should not travel or try to get a TN extension, basically until 485 is filed. Once 485 is filed, you get your advance parole, then you can travel. Okay.
Right. So the plan I was thinking is that perhaps we can do like the perm, right?
Yes.
And then we can have him on H1 B, and then we can do both simultaneously, I-140 and 485.
Hang on.
Assuming I-140.
Hang on. Let me correct you here for a second. First of all, you can never be assured that he will go through the lottery, he'll be okay, because that's a lottery. Second, if his priority dates are current, for example, he's EB2, not India born, then you don't have to worry at all, because once you file I-140, 485 together, priority dates being current, you'll get your advance parole within a few months, typically 90 days or so. Then he can travel, there's no problem. So overall, doing a perm and then I-140, 485 together eliminates the problem that you have. Okay.
Okay, but your priority date needs to be current, and his is not. If we do it today, then his priority date is not going to be current, right?
If his priority date, I don't know which country he was born, which country his wife was,
India.
which country his wife was born.
So he's a citizen of Canada.
No, doesn't matter. Doesn't matter.
India.
What is the country of birth of his wife if he's married?
India.
India. Okay. That means his priority date will not be current for several years. So I would be very hesitant, unless you don't mind losing the money, I would be very hesitant to start the perm unless I know for sure he's got his H1. Okay. So if money were an issue that you don't want to spend money on the labor cert and the lawyer's fees, what you could do is you could bring him in on TN, keep trying his H1. The year he gets his H1 is the year you can start his green card. Or you can keep doing his green card over and over again until it coincides with the H1. then file the I-140.
Okay, got it. Okay.
Okay? Good
Okay,
luck.
great. Thank you very much.
You're welcome. Okay, so TN, there was another question on TN. I won't get to it. I'll go in order. Let's see. H-4 EAD we did. TN we did. Okay, here is another very frequently asked question. I was approved earlier on H1. Am I now exempt from the quota? And I want to lay out the entire landscape for you. I have quoted the law here. Any alien who has, you and I are aliens, or I used to be, any alien who has already been counted within 6 years. So in the last 6 years, if you have been counted into an H1, you are not subject to H1 quota for that time. So what if I was approved from um, 2006 to 2009? So 2006 is not in the last 6 years today, but 2009 still is. And I have checked that with the government, and they said they consider the latter part. So 2009, when the petition was ending, they'll count from there. And if you are still within 6 years, then you are quota exempt. As long as, one, either you got a change of status and you worked on H1, or you got your visa stamping done, at least if you were outside USA. If you did not get visa stamping, or your petition was revoked or withdrawn before October 1st of that year, before you could start working, you would still be subject to the quota. This is the situation today, guys. Always check, because you never know how quickly this government changes its mind. Very difficult to keep track of it. Okay. So let's look at Vishal Rajpal's questions. Indian citizen, H1B expired, issue date was 2006, exactly the example I gave. Expiration date is Feb 2009, but hang on. Feb 2009 means in Feb 2015, you're over 6 years. Okay, so it does not look like you qualify for a quota exemption because you have not been counted in the last 6 years. Let's look at the law again. Any alien who has already been counted within 6 years prior to the approval of a petition described in subsection C, basically the H1 petition, shall not be counted again. So it looks to me like you don't qualify, Vishal. I think you have to go through the quota system. That would be my guess. Next question, oh, this is also frequently asked question. Any follow-ups on this issue, guys? *5. Any follow-ups on H1 quota exemption counting? *5. Okay, so let's go on to the next frequently asked question. How to maintain green card while working outside the USA? Well, first of all, once you get your green card, remember green card means you live permanently in the United States. Okay, if you want to go away for an extended period of time, you should file I-131, which is re-entry permit, same form as advanced parole, but you'll be applying for re-entry permit, which allows you to stay away for up to 2 years. It's a multiple entry document. You can come or not come for 2 years, but figure out, do a detailed consultation, one-on-one consultation with a lawyer, figure out the rights and responsibilities, figure out how that absence affects your stay outside USA and for naturalization. Okay, and look at also form N as in Nancy or N as in naturalization 470. Sometimes N470 is applicable if after getting the green card during any 12-month period you have been in the US without traveling outside, and you're going to go work for an American-owned company or you're an evangelist. There's a bunch of exceptions. You could actually stop the interruption of your naturalization because of an extended stay outside. But remember, if you leave USA, even for one day, intending not to come back, and you come back one day later, if the government is able to prove that you left with an intention not to come back, your green card can be taken away. Green card is subservient to the fact of actually living in the United States. There is a prerequisite: you are living permanently in the US. Many people think that if you keep coming back every 6 months or every 1 year, you will maintain your green card. That is not true. If you leave USA, you must leave with the intention to be gone for a relatively short period of time, probably less than 6 months, and a definite period of time. You cannot leave indefinitely for indefinite period of time. At least there should be some time horizon in mind. Okay. So if you travel to US every 6 months and return to India the next day, like Arjun G is asking me, they can take away your green card. Okay. So really the right thing to do is file for re-entry permit and explain the reasons and then renew it again. Normally 4 years, even 5 or 6 years is not that unheard of for renewals of your re-entry permit. So that is the right thing to do. I have a tweet here. Let me make sure. Oh, it's just somebody following me. Okay, just reminding you, if you need to tweet to me while we are talking, I'm following my tweets. You can use my handle immigration calm without the dot, immigration calm. Okay, any follow-up questions on maintaining green card? Press star 5. Any follow-up questions? Press star 5. Okay, let's go on to the next frequently asked question. I think we are towards the end of the frequently asked questions. Yes, this is another important one. This is an issue that has been coming up recently. If my old employer revokes the I-140, do I lose my priority date? The answer is yes. That's what the government is now saying. So I gave a link to a posting I had made a year or two ago. And at that time, government was of the opinion priority dates can be carried forward even if the old I-140 is revoked. On 6th May 2015, I updated it by saying that we are noticing that they have reverted back to the position that you will lose your priority date. Actually, the regulations appear to be saying that you will lose your priority date if your old employer revokes your I-140. Okay, so that decision, BIA decision and all, is irrelevant because that decision, the one that you have cited for me, Victor, is really not directly on point. More on point is the regulation itself. When you look at the regulation, it becomes quite clear that government's position is substantially justified under their own regulation. Sad, but that's the way it is. Anybody has any question on I-140 revocation and loss of priority date? Press star 5. Any follow-ups? Press star 5, please. Okay. No star 5. Let's see if there's another. Um, I'll get to this later. Okay, now H-4 EAD, H-4 EAD. Let's go back to the non-fact questions. These I'll answer at one go, and then we'll open up the floor for follow-up questions and then for new questions. So normal non-fact questions. Krishna. I-140 approved in April 2014, just before completing 6 years. Received H-1 extension for 3 years. Now after a year, if I switch employer, do I get 3 years or 2 years? USCIS is inconsistent. Sometimes they'll give you 3, sometimes they'll give you 2. For sure, they would give you 3 if you were in the last 6 months of your 3-year extension. But if you are somewhere before that, they might give you the remainder of the time, or they might give you the entire 3 years. Difficult to predict. I've seen cases go both ways. Monica had a problem with the petty larceny. Monica and I spoke. I have sent her some documentation. I think this must have been posted before we spoke. May 17th, yeah, we spoke last week. So, Monica, I'm not going to get into this because we already talked about it. Next question is, let's see, Kiran. Kiran says, I'm working on H-1B visa with I-140 approved EB3 for the past 9 years. Current H-1B is expiring Feb 26th. One of the question I think is it a good time to change employers now or wait until I get H-1B extension next year? You've got 3 years. Current one is expiring Feb 26, 2016. You can try getting an H1 transfer now and see if you get 3 years. Because if you get 3 years, then you've got plenty of time to start a new green card. Okay. Remember, USCIS probably can argue that they have the right to revoke an H1 if the I-140 is revoked, but they've never really done that. And I think it's a reasonable risk to take. I'm not that concerned. I think it will work out. So you could try getting an H1 now. If you get 3 years instead of only up to 2016, you are pretty safe to file a new green card. Okay. If I transfer my, okay, if the I-140 is revoked, you will lose your priority date, so the government says now. If new employer apply for perm labor in 3 months and the decision is pending, can I get H-1B extension for 1 year until perm approved? No, Kiran, you can get H-1 extension only on two bases. Either your I-140 is approved or the date from which you are asking for H-1 extension, on that date your perm would have been pending 1 year. Okay, so if I filed the perm today, I can, from about 6-7 months from now, I can file an H1 extension, but it will only be effective 1 year from today. So even though I can apply, let's say today is May, so I can, from today to November is about 6 months. In November of 2015, I can ask for an H1 extension for 1 year if my perm was filed today, but it will start only from May 2016. So I can ask 6 months ahead of time, but on the date the H1 extension is being sought, my perm would have been pending 1 year. Okay, so either I-140 approval or perm pending 1 year. You cannot get any third way for an H1 extension. Here's a good question from Raj IMG. If AC21 allows you to change employers after I-485 is pending 180 days, then is it not okay to leave as soon as you receive green card after 485 was pending more than 180 days and approved after 11 months, especially if the job profile is exactly the same? I think so. I think you have a fairly good case to make. See, there are a few dark areas or areas where really there is no clarity in immigration law. Unfortunately, there are too many of these areas. One of these is when I have received a green card and I change my job the very next day, can the government come after me saying, you did not have the intention to work on this position indefinitely because you left the very next day? And they usually raise this issue during naturalization. Then the counter at that point is, well, I have taken a substantially similar job. I could have filed an AC-21 if I wanted. But before I could do so, you approved my case. And that has happened in many cases. And usual advice I give to people is just make sure that you maintain some evidence that these jobs are same or similar. Okay. But I have always, look, I am not a college professor. It is not my job to debate the law. It is my job to protect my clients and to comply with the law as best as I can by creating as few problems as I can. So if I can avoid it, I would rather not get into an argument with the government. Okay, why would I even want to get involved in an argument? So the question is, if you are already in that situation where you already left, there's no point debating. But if green card is approved, make sure you have some evidence that on the date the green card was approved, you had no intention to quit. But even if 1 day later or 2 days later or 3 days later you get a job offer which is much more attractive for whatever reason, either it's in the same city where your wife lives, or it is closer to where children live, or it is much better salary, or it is much better promotion prospects, I think you can change, you can take it. The law only requires that on the date your green card is pending, you had no intention of leaving on any definite date. That's the real law. Okay. And I've spoken about this. There's plenty of material on the web as well as on our website about it, on our YouTube page as well. Okay. So then the next question is, Magnet 86 says that my H1B has been selected. I've won the lottery. I'm on OPT. But if I get denied, will I be able to get STEM extension? I don't know the answer to that question because I've never really looked at the regulations from that perspective. So I'm sorry, friend Magnet, I will not be able to answer your question off the top of my head. One thing you can do, I don't think SEVIP can answer this question either. Uh, you could talk to another DSO if you're not quite confident about your DSO. Although that 10-day grace period that they talk about seems unlikely. Of course, DSOs are experts in their own field, but maybe you can talk to another DSO. I don't want to give you a made up answer. Until I've looked at the regulations, I can't really tell you how it would work. Try the frequently asked questions also on ICE website because ICE is in charge of service and SEVIP. So try that. Okay. Next question is from Maher, an IT startup, Canadian friend, TN visa. Can he come as a consultant or as an employee if I want to do a green card? Employee is probably easier. It's probably easier. He's willing to work on a low payment. Can this create a problem? Well, TN does not require the payment of a certain salary. But of course, I mean, not the TN from Canada. Of course, if the salary is too low, the CBP at the airport could question the arrangement as, I don't know, perhaps a non-genuine arrangement. I think it'll be better if you want to do a green card. It might be better to just put him on W-2. But if you, for some reason, feel that 1099 works better for you, you should have a discussion with your lawyers because they need to look at your tax returns to see what the possibility of filing a green card with a 1099 in hand is. With W-2, what happens is, let's say you are paying him 60,000 and the green card salary comes out to be 400,000. I'm sorry, 100,000. There's a $40,000 difference. You only have to prove the difference of 40,000. But if he's on a 1099, it's not the same thing as a W-2. It becomes a little bit more complicated. Of course, there are arguments there also that 1099 reflects outgoing money that I would pay him anyway on W-2. There's something called ability to pay wages. That's what we've got to establish. So that's something you should discuss with your lawyers. It's not something I can give you advice on without looking at the numbers. Okay. Citizenship application, Rajiv GC. Nice name, Rajiv. I worked for a company that sponsored my green card and worked for them additional 1.5 years after receiving my green card. Then I resigned. When you resigned, they ran your pay stub for another 1 month, which overlapped the second company. I cannot help you fill the form. Remember, in the form, it asks at the bottom if you were assisted by somebody else in filling out the form and they have to sign the form. I can't do that. Information about your employment. Remember, let me give you a general piece of advice. First of all, having two or three or 10 payrolls running at the same time in your situation is not a problem. As a green card holder, you can simultaneously hold down 10 jobs. Nobody can question that. Okay. Number two, whenever you are in doubt, always tend to disclose more rather than less. So whatever your doubt is, you can put it down in the cover letter. Fill out the form to the best of your ability. I can pretty much promise you that they will not deny the application without giving a chance to explain. But if you hold back information, they can consider that to be fraud by concealment, etc., etc. That has its own problems. So when in doubt in a situation like this, over disclose. Okay, overlapping is not a problem at all. So Helix 113 wants to visit Iran. Is that going to be a problem for the green card? I don't know. It could become a problem if in security checks you run into an issue, and I do not know. I cannot predict the future. It certainly would be nice if you did not have to go through that, because certain countries, visits to certain countries, could trigger a little bit of a heightened scrutiny during your green card process. Hard to predict though. Uh, psha.rx says, I'm on a student visa, H1B approved. I got the approval letter. Can I change jobs before 1st October? Again, confirm with your lawyers. But the last time I spoke with USCIS on this issue, our office spoke with them. They said this: you can transfer before October 1st as long as they don't receive a withdrawal request from the first employer before October 1st. So either transfer after 1st, or make sure they don't send in, old employer doesn't send in a withdrawal request before the second case is approved. That's what the government said at that time. I don't know what this morning they're thinking. Double check, have your lawyers double check. But certainly it's a possibility. Um, Sunil says, I have an approved I-140 from previous employer. Oh, this is the part, this is the same extension of the same question. Would the priority date be revoked if the old employer revokes the I-140? And the answer is, it looks like it would. So you would lose your priority date. That's what the government is saying. WEDS 2000 says, H-1B amendment and the latest policy rule. Well, first of all, this is not really the latest policy. The H-1B amendment rule has been in place now for about 6 or 7 years. If somebody tells you this is a new policy, they are not familiar with the law. Okay, so this is the way I see it, and I think government has actually either ignored one area or given us incomplete guidance. I will tell you how to cover that. First of all, H-1B amendment is almost always required, except in one narrow case. And I'll come to what the government says. They have added one more case as an exception. H-1B amendment is always required, except where you are moving under the same contract within the same general area, normal commuting distance. So same job, same contract, same end client, same vendor, same everything in the same area. You don't need an amendment. But if the location is beyond normal commuting distance, if the job description changes substantially, if the salary changes substantially, all these cases may require or should require H-1B amendment. Government has said, and this is where they have left a little bit of a hole, and I think you should not assume that to be the absolute last word. If you move within the same area, we don't want you to amend. Well, what if I change my clients? I think you'll have to amend. What if I change vendors? I think you should amend. Why? Because the government can take the position that when you change vendors or change end clients, we want to examine the relationship all over again and make sure there's an employer-employee relationship. Okay. So let's see what your situation is. This was never that gray, actually. This was clear for the last 6 years or so. Within the same MSA, if you change the client location, there's no need to amend. Yeah, if it is the same end client, same contract, everything is the same, and you are within the same MSA, you do not need to amend the H1, but the LCA still has to be posted. And I would advise, at least I advise our clients, if you're going to post LCA, might as well just do an LCA again for the new location. That's the smart thing to do, in my opinion. Okay. So, how safe is this policy? Um, is the USCIS and the consulate on the same page? How safe is H4 stamping? I think H4 stamping is reasonably safe. But of course, you never know with the consulate what kind of questions they're going to ask. Um, but everything else, are USCIS and the consulate going to be on the same page? One can hope so. One can expect so. They're not always like that. But if you run into that difficulty and you show them this ruling, chances are they will be persuaded. Okay. Um, how safe is this? Well, this is written policy. It is as safe as anything possibly can be. So going for an H-1B stamping in this situation should not be problematic as long as the incidents of the job remain the same, the LCA was posted at the new location, or LCA was filed again. I think you should be okay as long as the job is essentially the same. All right. Next question, let's see. Victor also wants to had a follow-up question on the I-140 revocation. If in case my H1 transfer is independent of the I-140 revocation, no. If the I-140 is revoked before your H1 extension is approved, government can refuse to give you an H1 extension or transfer. Okay. And I already answered that question. If you're in the first year of your H1, will you get another 3 years, or you'll get 2 years remaining based upon the I-140? I do not know the answer to that question. That depends. Let me make sure I got everything. Yeah, I think we got it all. All right, folks. Any follow-up questions on what I have discussed? No new questions, only follow-ups. Press star 5. No new questions, only follow-ups. Press star 5. Follow-up questions on what I have discussed. Star 5. 2. 2. Okay. After this, we'll start the new questions. We have time. 2. Let me. This is a Skype user. Go ahead, please.
I have a follow-up question on a company sponsoring H-1B visa.
Okay.
Can a one-person company sponsor H-1B visa?
Yes, they can.
Okay, thanks. And are there any minimum requirements in terms of revenues, etc., that we need to worry about?
As long as the company is a genuine business with transactions, usually, in fact, there are rulings that say government shouldn't be looking at the company's financials. But one way or the other, whether they call it judging the genuineness of the job offer, they can get into all that. Usually they don't. As long as the company is a genuine company doing business, I don't think it matters. Okay.
And does the employer or the owner of the company have to be a citizen, or can they be on a green card? Is that okay?
A green card, for all practical purposes, a green card is as good as a citizen. Only thing you can't do is vote and a couple of other minor things, but you can run your business like any US citizen.
Oh, amazing. Thank you so much.
You're welcome. Okay, so the last follow-up question, and then we'll start the new ones. And this is New Jersey. Go ahead, New Jersey.
I have a question on H1 amendment.
Yes, sir.
Last year November, I joined a client and my employer has filed an amendment. Then I rolled out from that project, and from this April, I joined a new project, new client, but they are on the same metropolitan area, and even the zip code is same. They are just apart from 4 miles from each other. So do I need to file amendment? Because my employer is not ready to file amendment, they are saying that it belongs to same metropolitan area.
Well, that's what the government seems to have said. I think they kind of tripped up on that one. They didn't think it through all the way. But if they had thought it through all the way, they would have said, as long as it's the same Everything else about the employment remains the same, such as the end client, the degree of control, the vendors. Only then an amendment is not needed. I think it's the smart thing to do. If your end client has changed, even if it is in the same MSA, file an amendment. Okay.
Okay, one more question about that. Like, suppose I joined a new client, and can I find an amendment on the regular timing period?
I don't understand that question. Do you mean non-premium? Is that what you're
Like,
asking?
no, amendment has a premium processing also, right?
Yes, yes, yes.
So I am currently on new project, a new client,
Right,
and if I find amendment on a regular process, is
right.
it fine? Even if it takes 3 4 months?
Yes, because if you look at that memorandum, it says so. It says you can join the new employer as soon as you get the receipt for the filing. Okay. Or join the new end client as soon as you get the receipt for the filing.
I'm sorry, say it again. I didn't
You
get it.
can join the new job as soon as you get the receipt. I remember that's what the memo said. Double check that, but I think that's what the memo said.
Mhm.
Okay.
Okay.
Anything else?
No, that's it. Thank you.
Good luck, sir. Alrighty. Anybody, any question, star five. Anyone, any question, press star five. One, two. Okay. Folks, these are the only two I would be answering then. If you are sure you don't have any more questions, three. Okay. Please raise your hand now. Otherwise, I'll be only answering these three questions. Star five on your phone if you have any question whatsoever. There's a lot of people on the phone. Okay. All right. Four. Okay. All right. Star five on your phone. Five. All right. These are the only five I'll be answering, no more. If you raise your hand after this, because I'm budgeting my time. So, five questions is all we'll be doing. All right. Let's get started then. These are the only five we'll be doing. Let's go with Iowa first. Iowa, go ahead, please. Iowa, you're a
Hi,
cell phone. Yeah, go ahead, please.
hi Rajiv. Thank you so much for taking up on my call. Actually, I'm on H-1B visa. I've been on maternity leave since February, and February till April, I start working in May. Now I'm considering going for H-4 EAD. So if I have like, can I show like I have 3 months of, I don't have 3 months of pay stub. So can I show the pay stub of the current month and attach the maternity letter of last 3 months? Will that work for me in converting process?
Yes, ma'am. When there is a genuine reason for not being at work, you are not supposed to
Mm-hmm.
have violated status. We had a case, and I have quoted this many times, of a good friend who was hospitalized
Mm-hmm.
and was in a lot of health issues for almost a year. So she had no pay stubs for
Mm-hmm.
a year, but we were able to get her
Right.
converted to H4 without any problem in USA. We had a whole list of
All right.
things. So as long as there are a couple of things. First of all, if 3 months is considered to be normal, or there was a medical reason for three
Mm-hmm.
months, there's no problem.
All right.
You are very much within your status. Okay. If, let's say, even
Mm-hmm.
for natural love affection, I want to take another month and a half beyond normal, is that okay? I would say probably,
Mm-hmm.
probably okay, because
Mm-hmm.
it's a new baby. I don't want to just leave and start going to work. So I think 3 months is
Right.
not unreasonable, ma'am.
Mm-hmm. So like while filling out the form, like there are a couple of options where like they are asking
Give
like
me one
I
second.
can
Give me one.
specifically
Give me one
get
sec. Give me one
bank.
sec, ma'am. I will not be able to help you fill the form, because if I help you fill the form, then I
Yeah.
have to sign it. So, but if you ask me a
That,
question generically, I'll be happy to answer it for you.
okay. So is it like it's a general question. The change of status date, like I am looking for, can I put something like for ahead time, like 6 months later to be effective, or is it when like my when USCIS will approve my H4?
As far as I know, Well, first of all, change of status cannot be separated from your 539. Okay. Um,
Okay. Okay.
if it gets approved, it will get approved with the change of status. If you want to not do that,
Mm-hmm.
you should just go for H4 visa
Mm-hmm.
stamping whenever you're ready. Okay. So
Okay.
don't apply for H4.
Okay.
Uh, and certainly, if even if you ask for a future date for the H4 approval, USCIS does not
Mm-hmm.
usually honor those. They'll make it effective on the date they approve it.
Okay. So in my scenario, concurrent filing would be fine, right?
I don't see why not, ma'am. I don't see why.
Okay. And like, can I still keep on working until my H4 is approved?
No. That's one thing you got to watch out for. Oh, yeah, I'm sorry. The answer is
Okay.
yes. I wanted to cover that point also. You see,
Mm-hmm.
you are on H1, you filed for H4.
Right.
The way
Right.
USCIS seems to be going is they'll first approve the H4. The moment you
Mm-hmm.
are notified that your H4 is approved, you got to stop working, and you can only start working when
Mm-hmm.
the EAD is approved.
Oh, okay.
Okay.
Mm-hmm. So if there is an like different period of gap, like when my H4 is approved or when my H4 EAD is approved, during that duration, I'm not supposed to work, right?
Yes, you're not supposed to work between the time your H4 is approved because you're no longer on H1 and the EAD is approved.
Mhm. So, will we expecting like some kind of confirmation from USAs, like my H4 is approved and it will take this many days for H4 EAD or something?
They'll certainly send you an approval notice for the H4. I doubt very much they're going to give
Okay.
you an estimate of the number of days for the EAD.
Oh, all right.
All
All
right.
right. Okay. That's all I have, Rajiv. Thank you so much.
Good luck and congratulations on the baby.
Thank you.
Okay. Um, let's go on to the next one. This one is my neighborhood, Richmond, Virginia. Go ahead, please. Richmond, Virginia.
Hello, Rajiv. This is Mr. Abraham, and I have a question for you.
Yes,
Can
sir.
you hear me?
I can hear you. Yes, sir.
Yes. I have a question for you for filing a family-based green card.
Yes, sir.
So my parents visited visiting visa in year 2013, and they stayed for 6 months and they left.
Okay.
And this year I'm planning to bring them, and I'm planning to do a adjustment status of green card. So how once they come here, and can I apply for the green card for after how many months?
I
And the
always
problem was,
I always have a problem with this. Okay. There are many views floating around. I have seen people get into trouble. If your parents entered the US with a preconceived intention to apply for a green card, government can take an objection that the entry was fraudulent. Okay. I am told that there
yeah,
are BIA rulings that say no, no, that's not possible. I don't care what any body of law says. I have seen this happen. I have defended cases where government made that objection in the case of the spouse of a US citizen, for example. So the right thing to do is let them enter, have no plans of filing a green card. If after a few
hmm,
months, after 2, 3, 4 months, you decide that you want to file a green card for them and file an adjustment of status, I think that's okay. If the mind is changed, okay, even more importantly, it's their intention that's important, not necessarily yours. You could have an intention to file their green card, but don't let them have that intention. Once they come into USA
no,
after a few months,
hmm,
discuss it with them, and if they want to file it, they are okay with it, then go ahead and do it. But if they travel with their birth certificates and their marriage certificate, I think that's a problem.
okay. So bringing the birth certificate on, that's not be a problem, right? Because there is nobody is there to help them to
That's
get the
a
birth
that's
certificate
a
also.
that's a very long discussion. I would strongly recommend that you do a consultation, sit down with a lawyer, go over your entire case, understand what the different documents are. Normally,
Okay.
you will need a certificate of non availability from the municipal corporation where they were born. So, if they were born, for
Uh-huh.
example, in Ranchi, Bihar, Is it Ranchi is in Bihar? Whatever, Ranchi, and you need a letter from the municipal corporation of Ranchi saying that Mr. Ram Prasad, your father, has no record of a birth with them, and then you can get affidavits from two people who were alive at the time your parents were born. Usually, it's not a problem because we can always offer to do a DNA test. Proving parentage is not a problem. But birth certificate can become a little bit problematic. I mean, your birth certificate, of course, is there, but even if it were not there, we could have done DNA testing. But if it is their birth certificate, usually affidavits from two people who were alive at the time are okay. Otherwise, there are other ways we can find around it, other affidavits, copies of the ration card, things like that. Okay.
Okay. So is it something like from the church record or something like that?
Yeah, yeah, all
Birthday
those things.
shows.
If you don't have primary evidence, you can provide the secondary evidence because that's the way our countries are set up. A few years ago, there
Okay.
were no such thing as birth certificates.
Rajiv, sir, I have another question.
Okay.
If there is something like a spelling mistake or something like A and U has a change or
Not
something
a
like that,
problem.
but a person is same.
Not a problem. See, look at my name. Okay.
Okay.
Look at my name. I spell my name Rajiv. Okay. But people spell it with Rajive, Rajeev. There are so many different ways. These are phonetic spellings. Okay.
Yes.
So whether you spell your name Ram or Rama, it should not be that big a problem. It can be explained.
Okay.
All right.
Okay.
Good
Thank
luck.
you, Rajiv.
You're welcome. Okay. Let's. We've got 3 more questions left. Connecticut. Go ahead, please. Connecticut.
Yeah, my name is Sachin. Okay, I have one question. How are you, Rajiv, sir?
I'm good, sir. Thank you. How are you?
Yeah, I'm good. Okay, so I'm in second term of H-1B visa,
Okay.
and I haven't gone back to my home country, India. So I don't have a valid visa stamping. And next month I'm for going back, going for 1 month. I already got I-797 approved for my extension for another 3 years. It
Okay.
starts from 1st October.
Okay.
So if I go for visa stamping with the new petition, will I be able to come back in July because the new petition starts from October?
Okay, but you are not quota subject, are you?
No, no, my regular same employer, the regular H1B
Yeah.
and current
Your H1
current
your
employee.
H1B was an H1B extension, so you don't have any particular time. Am I understanding your question correctly? Are you saying you can only come back after 1st October? Is that your question, or am I misunderstanding?
No, no, no. Yeah, my question is my visa stamping for current H1B second term is not there because
Right,
I
right.
only got for
I got that. I got that. I got that. So what is the question? I'm sorry.
So my question is, I'm planning to come back in July, like I'm going in June.
Okay.
That is still in second term. But I have approval for next term. I already have approval for this term. So I'm not sure about the visa stamping.
Okay, hang on.
Where,
Let's.
how would,
I think I'm kind of following what you're saying. When does your current H1, not the extended one, when does your current H1 expire, sir?
30th July.
Ah,
Sorry, 30th September. I'm sorry.
30th September. So you're planning to come back
Yes.
within this term instead of the second term, the next term.
Yes, correct.
Okay.
So
So the question is,
yes.
somebody actually tweeted to me, and I've always told people that how early the quota of people can apply is really a local matter. But for all other visas, I think the consulate says 90 days, 90 days before the start date. So when does your next start date, when does your next date begin?
1st October.
1st October. Okay. So you're coming back in September. It's a very interesting situation. I don't know, Sachinji, if I have a good answer for you. There's no question that you can apply for a visa 90 days ahead of time. So we count back from September 90 days. That brings us to August to July. That means you can definitely apply in June or July for your visa. And the government also says you cannot enter until 10 days before the H1 begins. So your next term of H1 is beginning in September. So according to them, you should be able to enter only about September 20th, which is 21st, which is 10 days before October 1st. Does that work?
Okay, okay. So I won't be able to come back in July. So if
I
I
am
go for a visa stamping in June,
I'm making a guess here. I think if you go and get a visa stamping based upon the second term, even though you are in first term, for example, can they give you a visa stamping that begins from June? I don't know the answer to this question, Sachin. What you should do is
okay, okay,
let me suggest this to you. Send the consulate an email from their website and tell them that I need a visa stamping, but my next term begins only in October. But I want visa stamping to come back
okay,
in July during this term. Are you going to give me a visa for 3 years, 2 months, or what? I need to understand this. So they might just give you a visa for 2 months for all you. Okay.
okay, okay,
Because
okay. I got, I got
if you
it.
want to travel right away, they could say, well, okay, then we'll give it to you for this term. But if you want to get it for the next term, we'll give it effective October 1st, but then you can only enter USA beginning September 21st or so.
Okay, okay, okay,
Let's double check. I've never run into this situation
okay.
before, but I see a potential problem, so it's good to check with the consulate.
You said with the consulate?
Yes, and they do respond to emails. They may not give you very helpful
Oh,
information, but it's worth checking. Okay.
okay, okay, okay. I got it. Okay, thank you.
Good luck, sir. Sometimes these ideas can be so complicated. I wonder whether I make sense or not. I understand it intellectually, but am I able to convey it? I hope so. Okay. Next question is from New Jersey. New Jersey, go ahead, please.
Hi, Rajiv. This is Ram.
Yes, sir.
Thank you for your time, first of all.
My pleasure.
And I have a question regarding my wife's H1B.
Okay.
So she wanted to switch employers,
Okay.
and she has a notice period of 4 months. And during this time, she wanted to take maternity leave. So my question is whether if she can give notice period during her maternity leave or not.
There is no law under immigration that says she cannot. So, um, so your question is this. Let me understand. Let me rephrase your question. So your wife is going to have a baby. You're gonna have a baby. The question is,
Yes.
under her contract or her understanding with the employer, she's required to give a 4 month notice. Can some of that notice be rolled out from her maternity leave? And the answer is sure. Why not? Absolutely.
Okay, so there wouldn't be any problem because I mean we are too particular about this because I mean about the insurance
I
and
can
joining the new employer.
I can speak to immigration law only, and as far as immigration law is concerned, there's no problem.
Okay,
What you can do
okay,
is
that answers me.
you can check with their HR and their own lawyers who do employment law for them, and check with them. I would be surprised if there's a problem, but don't take my word for it. I am not authorized really to speak to any area other than immigration law, federal immigration law. Okay.
Okay.
Good
Okay,
luck.
yeah, definitely. Because I mean, we are too curious. I mean, we don't want it to ask their employer's lawyer because I mean, obviously they would be, I mean, they would be feeling like we are leaving the job. So
Well, immigration law
she doesn't
wise,
want to talk to them.
I don't see any problem, and that should be your major concern anyway. Immigration law wise, I don't see any issue.
Okay.
All right.
Okay. Thank you, Rajiv.
You're welcome. Good luck. And the last question for the day is from Florida. Florida, go ahead, please. Florida.
Hello, Rajiv sir. Are you able to hear me?
I can hear you just fine, sir. Thank you.
How are you, sir?
Very well. How are you doing?
I'm good, sir. Thank you so much. Sir, I have a question regarding my stamping.
जी.
I was planning to go to Canada for US visa stamping. I have a question on this. If suppose something happened and they did not stamp, will I be able to enter back to US?
No. The only exception is, well, two exceptions. One, if you already had visa stamping that was unexpired, so you had 15 days left on that visa, you could come back. Uh, or second, if you have an advance pro. See, normally, if you go to Canada, Mexico, Virgin Islands, etc., for less than 30 days, you can come back using a process called automatic visa revalidation. That means you can enter on the I-94 by itself. You don't need a visa stamp. However, AVR does not allow you to come back if you have applied for a visa and have been refused. So if you get refused, you would have to fly to India from there and apply again.
Oh, okay.
All right.
And is there any like scope of rejecting from the Canada or Mexico?
There is. People do get rejected. There is always a chance. You should sit with your lawyers, go over at least the most usual problems. Is the LCA for the right place? Am I working in the right place? Do I have any history of violations? Is there anything else that stands out as a visa problem? Go over those things with the employer's lawyers. As long as you've got those areas covered, chances are that if you got your H1 approval and everything went through smoothly, you should be able to get your visa stamping as well. But this is by no means guaranteed.
Okay.
All right.
Okay. And during this time when H-4 EAD is being applied, is it good time to travel for a visa stamping to Canada for my wife?
Remember what I just told in the beginning of this call. I don't think you were in the call then. You logged in about 45 minutes ago. I covered this area in the first 10 minutes of my conversation. Listen to the recording. It tells you what the parameters of the travel. I'll have the recording up by tomorrow. Okay.
Definitely. Yeah, sure. I will hear that. And the second question is like, suppose for H-4 EAD, is there any timeline defined that we will get back in this much of time to wait?
Well, government is under an obligation to adjudicate EADs within 90 days. I've covered this also. They usually don't meet that deadline.
I'll hear.
Yeah, just listen to. I think I've covered it all. If you have any issues, feel free to contact me again. Okay.
Sorry, I missed that initial session.
No problem.
Anyways, I'll hear that. Thank you so much for your help.
Thank you, guys. My pleasure. Folks, everybody, it's a great pleasure to speak with you, and thank you for the opportunity to assist you. 1 second, let me see. There's a Twitter. Okay, just somebody following. Okay, so I'll see you guys again in 2 weeks, every other Thursday as usual, and we'll talk. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.